Okay, well, welcome everybody. I hope that those online can now hear me. If you can't hear me, can you make some sort of signal? You won't be able to hear me asking you to do that, but any event, hopefully all our technology is in order now. So my name's Felicity Nagorka. I'm the co-convener of the Queensland chapter of the Australian Association of Constitutional Law. And I'd like to welcome you to this exciting event we have where we welcome Professor Steve Ross from Penn State University in the United States of America. So shortly I will hand over to our chair for today, who's Sandy Thompson, QC. But first I just have a couple of housekeeping matters. The first is that today's event is being recorded, but please turn off your cameras and your microphones if you're in the audience. That just helps with keeping our internet speeds up to scratch. If you have any questions and comments, and I understand Steve does welcome them, please put them in the chat function as we go along. And also from our IT help, we have a request, please do not take control of the presentation. On that note, I'll hand over to our chair, Sandy Thompson. I think you'd all be aware that Sandy is the Solicitor General for Queensland. He has an extensive public and private practice, including in the High Court of Australia. Thanks very much, Sandy.
Thank you, Felicity. Some of you may have noticed that I'm not sitting next to our guest of honour today. That's because on Thursday and Friday, the barrister on the other side of the matter I was appearing in the Court of Appeal notified me on Sunday that he's gone into isolation because his kids have contracted COVID. So I'm hoping to protect our guest of honour and others. So I'm very pleased to introduce and welcome Professor Stephen Ross. As alluded to by Felicity, Professor Ross is from the Pennsylvania State University, where he is the Professor of Law and co-director of the Centre for the Study of Sports in Society. He has a particular interest, by the way, in sports competition litigation. But today he's fulfilling another role in terms of a discussion about comparative constitutional law. At Pennsylvania State University, he is the Lewis H. Bavakis Distinguished Faculty Scholar. He teaches contract, comparative constitutional law, common law reasoning and statutory interpretation, sports law, sports and public policy, and is involved in a special project in baseball salary arbitration. He also has a number of visiting positions, including visiting professor at the University of Sydney Faculty of Law, where he teaches Canadian constitutional law. He is a senior fellow sports law program at the Melbourne Law School, University of Melbourne, where he teaches comparative sports and competition law. He has a visiting position with the University of Montreal, again in the field of comparative constitutional law, the University of London, City University of London, and the University of British Columbia, the University of Illinois College of Law, and the University of New Brunswick. And he's also a member of the advisory board of the American Antitrust Institute. In his past, his second job, I think, was to be a law clerk for the Honourable Ruth Bader Ginsburg when Her Honour was in the United States Court of Appeals for the District of Columbia Circuit. I've been provided with a curriculum vitae which is extraordinarily impressive, and I'm not going to take up his time in going through some of the enormous and numerous publications which are attributed to him. Today, he is going to speak to us about the subject of a comparatively paradoxical view on Australian constitutional formalism. And this is based, as I understand it, on what is described as early stage work in progress on formalist reasoning in Australian constitutional judgments. I notice on the screen, it's also described as a tentative work in progress. So perhaps his views may change as the work progresses. The discussion will centre on the differences, as I understand it, between Canadian and Australian constitutional judicial decision making, and in particular, his observations about the approach of the Australian High Court in relation to constitutional issues. Without more ado, can I ask you to welcome, please, Professor Ross.
Thank you very much, as we would say in the US, General Thompson. Let me see if there's a way to, without screwing this up, can you clear, is there a way you could clear the thing? And then let me just see if. All right, let me see if this works then at least. Are we going to change the?
It's this one.
Oh,
Yeah.
okay. So let me start by discussing the US view of formalism. And it's in the background of my own contrast between, as Sandy alluded to, Australian method, which is embraced by, most famously, Chief Justice Dixon in legalism, and that's all there is to it, with the Canadian complete rejection of legalism and adoption of what they call a purposive method of statutory, of constitutional interpretation. The formalist approach in private law was severely attacked in the US in the first half of the 20th century. And there's a widespread acceptance of the view that formalist reasoning was simply masking unstated judicial policy preferences. These preferences were objectionable, and that's a key part of it, and ultimately unsustainable on moral and policy grounds, as no longer conforming to real modern experience. As American scholar Philip Babbitt, imported into your shores by the wonderful constitutional scholar Roz Dixon, has noted, formalism excludes or downplays consideration of values and consequences and focuses on text, history, structure, and case law. The fundamental American point that's widespread is that in many cases, and certainly the difficult ones that reach the Supreme Court of the United States, text, history, structure, and case law do not give you the answer. You can make plausible arguments based on text, history, structure, and case law to achieve either result. There's a famous story I actually heard from Justice Ginsburg about Justice Brennan of our court, our Justice Brennan, not yours, who retired from the court and was still fit. And in our system, retired Supreme Court justices can sit by designation in lower courts. And he spent time sitting on the Court of Appeals for the District of Columbia. And he said, there was one hard case here. You guys have it so easy. All these other cases are so easy. Well, in the Court of Appeals, there are cases that are decided this way, but not, but doesn't really work that way for the more difficult decisions. I went too far. I apologize for my managing this. So modern judicial reasoning in the United States is based on two principles: social congruence and stability. And a rule is socially congruent if it can be justified morally. And morally doesn't mean the personal morals of the judge, but a widespread, it's more of a anthropological acceptance of what are widespread moral values, widespread judgments that a doctrine supports the community at large, and a widespread judgment that a particular doctrine is consistent with human experience of how people actually behave. Even when a judgment is not sustainable on current moral grounds, a court might well adopt it for reasons of stability, based on precedent, and two principal reasons for stability. One is reliance, that people have relied on the doctrine to organize their affairs. And the second reason is based on a really keen sense of judges. They want to create the appearance that the only difference in doctrine is the shift in the court. Again, I'm not familiar with Australian private law, I confess, but in the US, the common law we inherited from England, as some of you may remember back from law school, is the old notion of privity, that a manufacturer was only liable for a defective product to the party to whom they sold the product. Over about 50 years, we evolved to the point where now we have manufacturer liability for defective products. That's an example of modern common law reasoning. In the areas of certainly, for example, property and contract with regard to agreements or restraints that offend public policy, what is offensive public policy has changed over time. On the other hand, there are a variety of American state law doctrines involving property deeds that had been built up over time, and to change it as a matter of common law would have really wreaked havoc with relied upon expectations. And so those decisions were left to the legislature, even while the courts acknowledged that the old law was silly. And then you have your famous second senator's case, where two justices had been in the dissent in a prior case and actually flipped to sustain the precedent that they had dissented from, because of the appearance of that a major constitutional doctrine should not change just because of the membership of the court. And we saw in the United States, Chief Justice Roberts do the same thing in a recent abortion case. So these are sort of examples of this. Now, that's private law, but Professor David Strauss has written a great article and later expanded on a book about how American doctrine is generally common law reason. The text of our US Constitution is generally broad enough to fit either result. Now, there are cases where the original intent is uncontested and clearly applicable. So notwithstanding our Establishment Clause, which generally limits the role of religion in the public sphere, the Supreme Court upheld the constitutionality of the United States Senate, beginning with a prayer from the United States chaplain, because the first Senate that adopted the First Amendment had a chaplain who led them in prayer. And so it's pretty strong originalist argument. There is also a sense that in some cases, the original text and understanding is intended to be dynamic. So for most of our history, the court has interpreted the power of Congress to regulate interstate commerce as suggesting that things that affect interstate commerce is different from your interpretation of 51.1. Things that affect interstate commerce can be regulated by the federal government. And the example I use in teaching my class is drinking water. That would clearly have not been within the congressional authority when it was founded, because how did drinking water, if you went to the well and bottled water and sold it, how would that possibly affect interstate commerce? Today, since you can get a Perrier anywhere, that does affect interstate commerce. But the idea is intended to be to move forward in an appropriate way. So here's my perception as an outsider of Australian constitutional formalism. The High Court retains outward formalist reasoning based on text, structure, and precedent. The result is what Justice Leeming of the New South Wales Court of Appeals calls an archipelago rather than a consistent and coherent body of law. Each section has its own doctrines, its own precedents, its own text. It's actually consistent with a formal method. There are notable exceptions. And the notable exceptions from an outsider's perspectives are precisely those areas where the High Court recognizes that it cannot even plausibly create a necessary coherent judicial doctrine by a textual result that results in a single coherent meaning. And we see that from Section 92. We see that from the implied freedom of political communication. We see that from some of the decisions about Chapter 3 judicial power. There's a question, it's Professor Dixon, not Chief Justice Dixon. I should remember that there's a difference here. But Professor Dixon says that, well, you have to exhaust your orthodox methods. But that again gets to the question of what does it mean to exhaust an orthodox method? People who are non-formalists like me tend to think that there's virtually no text that really only has a single plain meaning. And the more you think that a text has an objective meaning, which you think, even if a bunch of other people in the room think it's different, but your view is the correct view, then that's an orthodox meaning and you can't use non-formalist views. So part of it depends on your view of text. Now, so the paradox is that unlike the American experience, much, though not necessarily all, Australian formalist reasoning is really perfectly defensible in non-formalist terms that is primarily grounded in a political process theory. Now, I don't suggest that this is necessary to you guys, that this is necessarily the best or the only result you could get on Australian constitutional doctrine, only that it is a plausible, coherent, and defensible strategy. Consider what I call the expansive textualism of Section 51. Unlike Canada, where there is a need for active judicial policing of federal power because of permanent demography, you have a national majority, a minority francophones that are always going to be a provincial majority in Quebec. You don't have that here, much as Queenslanders like to deride Victorians and people make fun of Tasmanians. You know, certainly from an outsider perspective, Australians are pretty much the same regionally. Secondly, per Madison's Federalist section paper number 51, the structure of Australian Federation puts ambition against ambition. You almost always have Labor premiers when you have a Liberal prime minister and vice versa, and they have both political and power-wise and policy-wise reasons to challenge any abuses on the other side. There's a key recognition of the unworkability of judicial policing. The Canadian experience shows where they actually need a judicial umpire, that so in the Tasmanian Dam case, the court, from an American perspective, correctly recognizes that if we really needed policing, and by the way, the Canadians do this, they would decide what is truly external and what isn't, what's close enough and what isn't. Whereas the High Court said, this is like really just policymaking, and we just do not want to get into this business. That is not our role. And we don't need to get in this role because effectively the political process will take care of it. Work choices is a great example to me of this. That decision, I would submit, is indefensible in formalist terms. The idea that the ordinary meaning of the regulation of trading corporations would be understood by anyone in 1900 to mean the regulation of labor relations of trading corporations is stretched and unfair and is just unpersuasive compared to the alternate meaning that it meant corporate law issues and things like that. Moreover, a standard technique of formalist reasoning is that if text phrase 1 might have 2 meanings, and one of the meanings is rendered superfluous by text phrase Two, you don't do that meaning. The federal, clear and innovative federal power over arbitrations of industrial disputes involving interstate is completely unnecessary if the corporation's power includes labor relations, because the only corporations that were the only industrial disputes that anyone cared about in 1900 were involving employers who were corporations. So you don't really need that power. So that's just standard formalist reasoning. The court rejects that. And why does the court reject that? Because where you draw the line in corporate power, there is no principal place to draw the line. So if it affects a corporation, the federal government can do it. And as we've seen by the legislation and pushback on work choices, the political process actually works to deal with the situation. In contrast, and I think this is illustrative, and the court does not acknowledge this, and again, I'm not suggesting it's the right result or the wrong result, I'm just saying it's plausible, that what's notable to me is that the court takes a very different view in the Williams case about whether having a chaplain in a school was a benefit to the students. And it takes a more narrow view of this. The reasoning is interesting. The court just rejected the SG's arguments without actually offering any positive result of the theory. And but to me, there's actually a distinction. When Canberra acts to directly regulate educational policy, you'd get a lot of pushback from Premier. When Canberra acts under is it Section 96, the grants power? When Canberra offers a conditional grant under Section 96, you get potential pushback. But where's the pushback if you've just taken a political hot potato off of the desk of every premier by saying, we're just going to give money to school chaplains? Now, when people like Mr. Williams complains to the Queensland premier, they say, well, take that up in Canberra. We didn't spend, it's not our money. We didn't spend it. Nobody's going to object to it. The political process is not really working. So it seems to me again, I'm not arguing it's correct, but there is a defensible argument that the court needs to be more actively involved in determining whether a pure unconditional expenditure is for a Commonwealth purpose than it does in other areas. The court has been emphatic in rejecting the notion of the American notion of a regulatory taking, that the government takes property when the regulation goes too far, and has made it clear that the emphasis ought to be on what is the Commonwealth acquiring, not what the affected private party is losing. Again, because the whole idea that a court is going to decide when it goes too far is something that is not consistent with the court's vision of its own role. Even the very controversial decision in Al-Khattab can be justified. I'm not saying it is justified, but can be justified on these grounds. Now, I appreciate it's contested, but if we accept two highly contested Australian law pretexts, which I'm just going to accept for purposes of my argument, that there is no international treaty that Australia, to which is a party, that requires Australia to allow stateless people to remain in Australia. So again, I know that's a very complicated issue, but let's just assume that is correct. It's at least plausible that Australia would not have such an international treaty obligation. And let's further assume, which I think is much stronger historically, that there is no implied individual right to just about anything in Australia. Your framers explicitly rejected a due process clause, and so there is no individual right. So what's the solution? The solution is really a political solution. You either let the guy stay in at some point or find another home for him. And who's got to do that? The federal government has to do that. And as to people who say, especially, I'm doing this deliberately jiu-jitsu, but especially for people on the left who say, well, the politics is messy and it's going to take some time and it might not work, I go back to your sacking of Whitlam crisis. What was Prime Minister Whitlam's argument about the constitutional crisis? he claimed, and American experience clearly proved this 18 years later, this is not an existential crisis requiring constitutional intervention. Somebody's going to blink. Government's going to get shut down. At some point, the liberals would fade and Grant supply, or at some point, he would blink and make whatever political accommodations he needed to make. He did not need to be sacked. And my point is, it'd be a little messy, but at some point, somebody was going to blink and somebody would have done something for Al-Khattab in some way. And it seems to me that, so even here, it seems to me you have a political process at work. So what is sort of a puzzle, and why I call this a paradox, is that American judges who rely on formalist claims to mask their reasoning are widely seen as illegitimate. It's just broken down. Australian judges who honestly acknowledge that formalism is inept and candidly explain their actual reasoning fear that they will be seen as illegitimate. It's not exactly clear by whom they fear this, but that seems to be the case. And Australian judges seem to prefer formalism even when it results in a judgment that insists by ipse dixit that a claim is based on text when there is no clear answer from text. It's based on a necessary implication from a structure when history can be read both ways. And they just sort of prefer that. And I would refer you to the actual text of the reasons of the Joint Court in Canavan, which is completely formalistic, to the extrajudicial commentary by Justice Gagler on Canavan, which is much more honest and candid about, about what he's doing. So, so then the question is, so what? This might be intellectually interesting, and here's this American telling you guys about stuff. And this is the part of the tentative. I don't really still have a comfortable answer as to why judges believe the way they do. A fascinating insight is offered by the legendary Professor Zines in one of his early books. And it is actually counter to their role, very Machiavellian notion that politicians find it difficult to unpack this sort of thing. Now, when it comes to political obfuscation, politicians are very good about this. And I don't have a precise Australian example, but I can offer, since most of us follow these areas of the world, what's going on in the UK. So the UK currently has a prime minister who finds it politically convenient to be less than transparent about policy views and to offer reasons that are not the actual reasons for pursuing government policy. And among the reasons that the loyal opposition selected Keir Starmer as their party leader is he's a skilled barrister. And they find him to be particularly good at unpacking and unmasking the prime minister's statements, etc. So what are the implications of my thesis? And first, for advocates. My invocation for advocates is, if the court is, as it appears to me, masking their policy, you need to include both policy and formalist arguments in your submissions. That you need to create an argument that says, whether or not you really believe it, the text, structure, precedents, etc., all support this result. Part two. The text, structure, and implications are all supported by these reasons. Because if you don't include the court's thinking about those things anyway, and this way they get the benefit of the adversarial process. The second implication is for politicians, that if Professor Zines is correct, you just need to hire smarter people and more legally sophisticated people. And one of the projects, as I'm going to develop this into an academic piece, is to actually try to collaborate with some politicians in Australian state either in Brisbane or Canberra or Sydney or elsewhere, to sort of explore, if there was a politically formalistic controversial view, how could you come up with bullet points that unmask the policy and criticize the court on the grounds that they're adopting a particular preference that you, the politician, doesn't really agree with. And I don't know what would happen after that, but to the extent that that is the theory, that is the implication for politicians. I said this is highly tentative, and as I told some of the people up here coming over here, one of the great features of being a senior professor is that when I was a junior professor, I never wanted to share my work with anyone except very close friends until I was absolutely fully researched and sure it was done. Because if I did something and somebody told me it was really off base, I would say, oh God, I'm so embarrassed and my career's over, etc. And now I'm at a point in my career where if I come out and offer these tentative views and somebody in our conversation just completely demolishes it and explains to me why this is completely wrong, my attitude is, you've now saved me a lot of time. Thank you. So I look forward to polite but completely candid questions or comments. And thank you very much for your attention. How do you want to do this?
I was going to suggest that I invite people to put questions first, and then I might say a few things. So, a bit of this.
Thank you, Professor. So, first of all, anybody in the room who'd like to raise any questions in relation to Professor Ross's presentation? Ken Law, thank you.
So my question is about the possibility that judges are true believers and that they are actually possibly not consciously masking with formalism, but they are actually formalists. And part of that I wonder about is in the changing world where there's polarization of values. Maybe formalism is a kind of value that we can all agree on in the legal community, so that there's a common language. Whereas if we move to values, there's nothing in common. Everything is polarized.
So the question is, are judges true believers and they really believe in formalism? My hypothesis is that the hard cases involve non-formalist reasoning. And it may not be a deliberate mask of a conscious policy preference, but it is a reflection of a policy preference. Now, there's a strong English tradition of formalism, which worked certainly in, up until the 20th century, because who wrote the common law? Judges. Who were the judges? The second sons of aristocrats. Who wrote statutes in the age of statutes? Barristers who were legislative counsel. Who were the barristers writing these statutes? The second sons of aristocrats. So when everybody's sort of the same and everybody speaks the same language and shares the same values, you can have that system. There is a huge amount of constitutional law where we try to unmask the actual underlying values that people in a country think about just naturally. A preeminent American constitutional law professor gave a brilliant talk once on this rich body of doctrine we have in the United States between presidential power under Article 1 and congressional power under Article 2. And it was really a great talk. But he started it by saying, well, the key value is separation of powers, and we all accept that a key condition of liberty is the strict separation between the executive and the legislative. And afterwards, I raised my hand and I said, I wonder if you could address the abuses that the people of Australia are suffering under the Ayatollah of Canberra, because in Westminster systems, there is no real separation between the executive and the legislative. And he just looked at me like I was weird. So when you say that they are true believers, I think it could be true, but all that means is that they are failing to come to grips with their own accepted preferences on what's really going on. And now, one policy preference is to strongly value stability over modern social congruence. And so you can take the second senator's judgment and expand it so that any decision of the High Court of Australia in 1901 is something we have to automatically follow today, no matter what. And you could say, well, I'm just being a formalist following precedent. That's a huge policy choice on how you want to govern and interpret your Constitution. And nobody, and I mean, that's the point in the United States when, you know, they had these famous debates turned into an opera between Justice Antonin Scalia and Justice Ruth Bader Ginsburg on a living constitution versus originalism. I mean, it was much debated, but nobody claimed for a minute that this wasn't a fundamental policy choice that both Scalia and Ginsburg were making about how to interpret the Constitution. Other questions from the room? Yeah, Felicity.
I wonder, and I don't pretend to be I wonder whether someone like Sir Owen Dixon saw formalism as sort of constraint on the subjectivism that might come into play when one focuses more on values, so that it might perform a kind of and I think I know what your answer is, but that's rubbish because there's no objectivity. But I just wonder if that's something you've thought about at all, that formalism can act as a sort of constraint on what judges might otherwise do.
Well, it is a constraint, which itself is a policy choice. So if you say we're going to interpret a text the same way a prior court interpreted a text, that's a policy choice. Now, constrains you, if you didn't have that choice, you might decide it in another way. And you might decide it on your own personal values. And you might well decide that. I'll give you a completely political, no one says formalism here. The United States has not substantially amended its labor laws since 1935. There have been a couple of significant amendments, but for the most part, American labor relations today is the Wagner Act of 1935. Now, there have been times when the Democrats had complete control of Congress, and there have been times Republican and the presidency, and there have been times Republicans have had complete control of government. But people don't want to do that, mostly because there's a general agreement between Democrats and Republicans that you don't want a system where every time the Democrats come in, you get this big pro-labor law. And then every time the Republicans come in, you just get this pro-management law. This is pure politics. There's no formal, it's a constraint that they've both agreed to. So it might be that that judges decide in any particular case, we're going to adhere to a certain doctrine, or we're going to adhere to a particular text, because we don't want to have, I don't know, whoever your most conservative and pick whoever your most liberal justice is currently on the High Court. And we don't want them fighting to see who gets 4 votes. We're just going to do it a certain way. But that's a choice. And that's my point, is it is a choice. And you can adopt more constraining or less constraining choices if you want. The notion that Section 51 is, I would say, non-formally interpreted in this extremely expansive way is a choice. It works to be a restraining choice on the judiciary. It basically says we're going to stay out of the business of actively policing what is an external affairs power, what is a corporation's power, etc. That's a restraint that the court, I think by consensus, has agreed on here in this country. And because they've seen perhaps the challenges in Canada and the US when judges try to get more involved and figure out exactly what, how far is too far and what's going on. And they completely reject, some of the notions that I know Justice Anthony Kennedy in the United States has set forth, which is that the court has to maintain structural federalism by assuring that the federal government doesn't go too far. And, high court judges just don't want to do that at all.
Thank you for your talk, Professor. It's very interesting. My question really is, we now have a radical conservative court in the United States. Is that radicalism likely to express itself in any way with regard to formalism or non-formalism? Although the existing techniques must be used to achieve radical results?
So I've never been a very good prognosticator. My sense is, and there's no unbiased view about this. So all I can respond is my own bias as someone who doesn't share the views of the majority of our current court. I always thought this was far-fetched back in my days in Berkeley in the 70s, but I sort of think we need to hasten the dialectic. And it's going to get worse before it gets better. And I think we are currently sort of like the US was in the late 20s and early 30s, you had a right-wing, anti-democratic, activist court distorting constitutional preferences for an agenda that ultimately is not supported democratically. And what's going to happen is it's going to reach a crisis point, and then it's going to spill over, and then there'll be a reaction again, just as there was in the United States in the late 30s when they got rid of all those doctrines. But the notion, for example, to take one of the more infamous decisions of our court, where the court struck down voting rights legislation passed by a Congress under the power given to them after the Civil War by the 15th Amendment to take on southern states that were oppressing Black people. And they struck it down because what they basically found was in their opinion, there was no need for it. And the discrete and insular minority that needed protection were racist local governments in the South, because they didn't really have a voice and they weren't really being protected. I mean, that sort of approach which the court has taken, I think Justice Ginsburg was correct in her dissent that this decision has no staying power. But before it gets reversed, I think it has to get better. We have a particular problem in the United States of unprecedented proportion in the politicization of the court. And that's the other question. So the bad news is it's not going to get better. And I will use this in my own experience with my own students. It was very typical. First year constitutional law constitutional law is a first year subject in American law schools. And so you get all these bright first year students, and many of them who speak in constitutional law are strongly political, either the left or the right. And they always come up with these great doctrines to achieve their left or right wing policy goals. And it's always fun as the professor to then say, well, what happens if a court which doesn't agree with you gets to use these same tools? And up until about 5 years ago, this was great. And they go, oh, yeah, I guess that's right. I guess, a good example is, should human dignity be read into the Constitution? And quickly becomes apparent that, nobody really likes that idea, because half the court and half the country thinks human dignity means every woman has a complete constitutional right to control her own body when it comes to reproductive choice. And then the other half thinks human dignity means protecting the dignity of unborn children. So then it's sort of everybody goes, oh, I guess you're right. Oh, you're such a smart professor. And now when you say, well, suppose you take your doctrine and then people who don't agree with you go the other way, students will typically say, well, then it's my job to vote for a new president who will pack the court with people on the other side. And, if that's going to be the majority attitude in the United States in terms of what I call constitutional politics, then we really don't have an independent Supreme Court. Again, I don't know if you have this in your country, but our National Labor Relations Board is actually a good example. It's been commonly accepted since the 30s that when Democrats are in control, they pack the National Labor Relations Board with labor-friendly board members, and they rule in favor of unions. And when the Republicans get in, they pack the board with management-friendly people, and they rule in favor of management. And everybody sort of accepts that's the way it is, and there's a wide range of within the law, and courts will uphold either way. And that sounds like what many Americans think the U.S. Supreme Court ought to be.
Professor, we had a couple of questions that came in on the screen.
Oh, I see.
The first, perhaps, if I read out, Dr. Thermal Barrington has asked you what will be the outcome of your study eventually.
So, well, it depends. My approach to most things in life is not to jump in the deep end, but to put my toe in the pool and then my ankle, etc. So as I continue to wade until I get to 6 feet in the pool where I start to swim, if I'm not dissuaded, my idea would be to write a book on Australian, from an academic point of view, on this dynamic and sort of analyze what Justice Lehman calls as the archipelago of constitutional law, and sort of offer plausible political process explanations for much of Australian constitutional doctrine. And then at the end, to then have a chapter where perhaps advised by some people who have experience in politics, to offer like some draft press releases that either the Ministry of Justice or the shadow minister could use to try to deconstruct the High Court opinions and talk about the preferences that the court is doing. But the alternative is somebody will email me within the next 2 weeks and say, oh, I saw your presentation, thank you. Here's where you're completely wrong. And I'll read it and go, you know what, good point. And I'm going to move on to something else. Can you scroll down so I can see some of these?
I think we have another question. Right.
So the
John?
Yeah, let me read it on the mic. John asks, it can look the Australian Constitution can look like a customs union. Does this not lend itself to a naturally formalist approach as a consequence? I'm not exactly sure why that would be true. To think about the one major document that is clearly a customs union, which was the treaties on the European Union. The European Courts of Justice, once they created them, have adopted decidedly non-formalist approaches to what constitutes the notion that there's the member states of the European Union have actually, to use a very non-formalist Australian and somewhat controversial Australian practice. Your court implies an implied freedom of political communication and then adopts a proportionality standard. And I know that's somewhat controversial in Australia. For years, from the outset, I think, the European courts have interpreted the provisions of the European Treaty that provide for the free movement of services and the free movement of labor within the European Union. And what does that mean? It's a proportionality standard. Governments can do things. The first question is labor being impaired? And if the answer is yes, then the next question is not, you can't do it, but you have a good reason for doing it. And if you have a good reason for doing it, then the third question is the actual statute a proportionate way of achieving your legitimate objectives? And if the answer is yes, then it's not a violation of the free movement principle. So I would say that customs unions are not formalist in what they're doing at all, really. And they are, in fact, customs unions are seen expressly as empowering community-wide institutions to adopt non-formalist reasoning for limiting various activity. Please include the disenfranchising of the First Nation peoples of Australia. So I am just literally dipping my toe with some work from some others on, I do have a chapter in a revised book and materials on Indigenous people. And I think that's it's a really interesting question. How the court has dealt with it is really not in this area of expertise for me. From a political process point of view, it is clearly an area where the court needs to independently make its own decisions on things. I think there is a very good argument, certainly, that the landmark precedent in Mabo is a non-formalist recognition, in part, that the political process isn't going to just work, and the court needs to come up with some decision. Somewhat more controversially on the indigenous people question, though, is I just raised this and would invite anybody to email me you can just go to Steve Ross, Penn State Law, and you'll see my email, and I really invite anybody viewing or people here to do so. But one of the questions we raise in our materials concerns the absence of an equal protection clause in an entrenched constitution, but raises the question, which from an outsider is a very troubling but interesting question, which are the Northern Territory intervention. And from an outsider's perspective, it's a very complex issue, and all I know about it is serious social problems among Aboriginal peoples of the Northwest Territories from, centuries of victimization, a means of intervention to try to address social problems, strong opposition to those problems as heavy-handed and paternalistic by many Aboriginal groups, support for the problems by many groups of Aboriginal women who see the intervention as more appropriate. And then the question is, who should decide whether the Northern Territory intervention is a good idea or not? When I think about how our US Supreme Court deals with race in a very ham-handed, artificial way, it is not clear to me that that would be the actual best way to proceed with the decision. I can tell you, for those people who are critical of the Northern Territory intervention, you would have a big ally in Chief Justice John Roberts of the US Supreme Court, because he would say this is blatant racial discrimination, and the only way to avoid discriminating on the basis of race is to stop discriminating on the basis of race. So any distinctions on race would be absolutely banned according to him. That decision would probably be 5-4 in the US Supreme Court. And the question for Australians is, do you really want these complex issues of the Northern Territory intervention to be decided on a 4-3 vote of your High Court, especially if it were clearly done on ideological grounds? So that's my one I don't have an answer at all to that question. And but the question, I appreciate the question, because it means I will either need to deal with this in my forthcoming project or expressly say, this is just too complex a question for an outsider, so I'm expressly ducking this very challenging question of dealing with Indigenous people in Australia.
Thank you, Professor, for a very interesting and engaging presentation. I, for one, was going to ask you whether you thought the UK Supreme Court had abandoned formalist reasoning in relation to proroguing Parliament. It seemed to me, at least, that was an indication of a shift in the UK. We have a little presentation that we wanted to give you to thank you for participating. We know that you have a significant interest in sporting law, and so as you're in Brisbane, you'll find that is reflective of the population's view about rugby league football in this state, or in this city at least. Unfortunately, they lost last night. But can I just thank you again on behalf of those present and also those viewing, and I apologise to those who are viewing who submitted questions that we weren't able to reach. Thank you again.
Just very quickly, thank you so much for your amazing hospitality. Anybody who has further questions, please send it by email. I have to confess, I got into Australian sports law by representing the South Sydney Rabbitohs in their litigation to get back into the competition. I have become an active member, and this symbolizes people whose rapacious spending stole Adam Reynolds from our Rabbitohs by your willingness to give him a 3-year contract. So I view that, I view the thought more than I just want to make it clear to my Rabbitohs friends in the area that I'm being polite and accepting this hospitality in that regard. Thank you again for joining, and please do let me know if you have follow-up comments by email.